In mid-June, President Trump announced that they would be doing mass immigration raids conducted by ICE to arrest thousands, hundreds of thousands of persons who already have outstanding deportation orders. Even though this plan was delayed, we now know that there is a plan in place by Immigration and Customs Enforcement to start arresting hundreds of thousands of people who have deportation orders. Today, I want to address who those people might be and how you can prepare for that. Basically, immigration will probably be going after two categories of people who have final removal orders. By a final removal order, that means that either that person went to court, they had their day in court, they filed their application maybe for asylum, maybe based on the 10 years in the United States, maybe based on the perdón because of an offense they had, and that application was denied. That person filed an appeal to the Board of Immigration Court, to a higher court, and eventually that appeal was denied. And as a result, that person now has a final removal order. The second category of people that the president will probably be looking for who have final removal orders are people who are actually picked up by immigration, maybe when they came into the United States and were released to go to a future hearing date in court someday, and then they failed to show up. And those persons got what's called an in absentia order by the immigration judge because they failed to go to court. Those are the two categories of people that the president will probably be arresting because those people already have final removal orders, and because they either went to court and they lost their case or failed to go to court, they do not have the right to go back to a hearing with an immigration judge and ask for a bond and go through all the due process rights. For persons who went through the hearing process, who went to court, who filed their applications, who lost their applications, and then lost their appeal and got an order to leave and didn't leave the country, their only relief, if they are arrested by ICE, is to file a stay of removal. To file a stay of removal, you must have a current and valid passport. So to all my clients who have this situation, who we did their case years ago, who we filed an application based on the 10 years of asylum and we lost the case, and then filed the appeal and we lost the appeal and we got their final order, but they stayed. What I'm telling them is, if you're going to try to do the stay of removal, you need to get your current passport, and then give that passport to a family member. Because if you get caught by immigration, you're not going to have access to that passport. So you must leave that passport with a family member who they will be in charge of contacting the attorney and trying to prepare your case. A stay of removal does not reopen your immigration case. A stay of removal does not take away your deportation order. A stay of removal is just asking ICE to release you temporarily, maybe for just a few months, so that you can take care of, maybe in some cases, family situation. If your kids are in school and you want them to finish the school year, ask them for a few months till the school year finishes. Maybe you want to sell your house, you need to sell the house because you have property and you want a few months. It will not allow you to stay in the United States indefinitely. If it's granted, you will be released from immigration custody. You will have a few months to do what you need to do. But if you're going to try to do this, you must have a current passport. And this only applies to persons who did go to court and filed their applications and filed their appeals and lost their appeals. The second category of people with these final removal orders are people who were caught by immigration and never went to court, and they got an in absentia order. For these people, the procedure is much more complicated. First of all, the only way you can reopen a removal order for not failing to go to court is filing a motion to reopen with the immigration judge. When you file that application, it'll be up to the immigration judge to make that decision. The judge will probably take about 2 to 3 months until that decision is made. During that time, you will remain in custody. You will be detained by immigration during the 2 to 3 months while the judge decides whether they're going to reopen the case. For a motion to reopen to be granted for failing to show up in court, you must show that it was not your fault that you didn't go to court, either because, number one, you didn't get the hearing notice, maybe you sent to the wrong address, or number two, the day of the hearing, you were in an accident, or maybe you were in a hospital, or maybe you were in jail that day for driving without a license and you couldn't go to court. In those situations, you may be able to get your case reopened because it was not your fault or through a failure of your part to go to court. If, for example, you did not go to the hearing because you didn't get the hearing notice, it's going to be up to you to prove that immigration didn't send the hearing notice to the address you gave them. Now, in a lot of situations, they do. They send it to your address, and it's very hard to prove, well, I didn't get that letter. On the other hand, immigration makes mistakes. And sometimes they will send it to the address but not list the apartment number. Sometimes, and I had a case just like this recently, My client's address was 11651. She didn't get the hearing notice. She got a removal order. But when I went to look at her file, immigration had sent it to 1651. They had left out the first one in the address, so she didn't get the hearing notice to her correct address. It wasn't her fault. We were able to reopen the case. But if you think you're in that situation where you have a removal order because you failed to go to court and you think it wasn't your fault, it is important, now that we know that President Trump has this plan in place, to contact an immigration attorney and begin getting the proof that it wasn't your fault you didn't get the hearing notice. It took me 30 days to get those documents from my client. Luckily, she wasn't detained, but once I got those documents from the court, I was able to prove it wasn't her fault, and we were able to file the motion to reopen with the immigration court. So if you think you're in that situation, you want to start getting your documents, your proof that it wasn't your fault, in advance, not until they come knocking at your door and they arrest you. The third possible thing to prepare for is what immigration is calling collateral arrests. And what that means is this. When immigration goes to the house with the arrest warrant to look for that guy who has the deportation order, and his cousin is there, or his wife is there, and his older son is there, and none of them have papers, those persons can also be arrested and put in removal proceedings and deportation proceedings as well. I recently had a case where someone was arrested in this situation. Immigration had an arrest warrant out for someone who had a prior deportation order. My client was a passenger in this car. He and the other guy, three of them worked together in construction, and every day they'd carpool together and go to the construction site. It just so happened that the guy who drove the car was the guy who had the outstanding deportation order. Immigration stopped his car because they knew that he was the owner of the car, and they wound up also arresting my client and the other guy because they didn't have papers. Now, this is important. If you are arrested because of a collateral arrest by immigration, and you do not have a deportation order, you have all the rights that all immigrants have in this country. You have a right to a hearing with an immigration judge. You have a right to a bond. You have a right to talk to an attorney. Exercise your rights. Tus derechos no sirven si no los aprovechan. So if you wind up being caught by immigration as a result of them arresting someone else who has one of these removal orders, but you do not have a removal order, you never had to go to court, you've never been caught before, do not sign anything. Ask to speak to a judge, ask to speak to a lawyer, ask for a bond. I give all my clients a little red card that has their rights listed in Spanish and English, and it just reminds them that you must exercise your rights. My name's Fernando Dubove. I'm an immigration attorney, and for over 25 years I've been doing exclusively immigration law. This most recent announcement from President Trump is not new. Going back to President Clinton, immigration has periodically conducted these mass raids when they went after and arrested people who had outstanding deportation orders for either failing to go to court or not leaving when they were supposed to leave. This is just the first time the President's given us the benefit of telling us in advance we're going to come looking for you. I hope this video provides you the information you need to prepare for that situation if you fall in that category. Thank you very much. Have a good day.